We are back on Morning Line. Thanks for joining us. Nick Barris coming to you live with the lovely and talented Barbara McGinnis. I always like having her on. She's joining us for the first time on Zoom. I guess you're on Zoom, right?
We are. We're on Zoom.
Look at us. We're getting it done. And this is the way I know you've been dealing, you and Tim Takis, with elder care attorneys, a lot of your clients over the past several weeks. But really appreciate you coming on. And I'm glad. I think it's important for us to talk about this during the pandemic. We have a caller that waited through the break, Barbara. Let's go to Virginia.
Okay.
Virginia, good morning. Do you have a question or comment, Virginia?
Yes, I do.
Okay, ma'am, you go ahead.
I am 90 years old.
Wow.
I have a bank account with me and my daughter.
Okay.
She has MS.
Mm-hmm.
She cannot use any of her body, nothing but her mouth.
Okay.
And I've been trying to get my son's name put on our checking account so that if something happens to me, she can get some of her money. And I can't find out what to do. I don't want him. Somebody told me that I could put him on it, but his name wouldn't be on the check. But if she needed anything, he could get it for her.
Okay, so you want to make sure you set some money.
I want to know what I got to do.
Okay, all right. So, Barbara, it sounds like this is a woman in her 90s, a daughter that she loves that I'm sure needs round-the-clock care, and she has money she wants to leave for her, and she wants to make sure to do it right so that her daughter gets what she needs after she's gone.
Well, let's see if we can work through this a little bit.
Okay.
She said it was a joint account between her and her daughter. So a joint account, then there's mutual ownership. So if something happened to Virginia, the money would belong to daughter. If something happened to the daughters, the money would be Virginia's. I would do a couple of, but if it's not really a joint account, if it's just mom's money and she wants the daughter to be able to access or use the money when she passes, there's a couple of things that you can do. One, I mean, certainly you need to talk to your bank to see what they would recommend. The son probably needs power of attorney for mom so that during her lifetime, if she becomes incapacitated, the son could go to the bank, power of attorney document, access the funds, and be able to continue to pay bills, use the money as it was intended for. If she's just worried about transfer on death, perhaps the son needs to be a payable on death designee. That's, again, something you have to do with the bank. So you might do one or both of those things to make sure that the account is set up properly. If you truly want the son as a joint owner on the account, which I'm not sure I recommend, but if that's really what you want, you would go to the bank. The son would have to sign some documents, and it's nothing you can do outside of going to the bank if you want to add somebody to your bank account.
Yeah, it sounds like she maybe wants the son to kind of supervise the money. I don't know if she fears that the son might spend some of the money on himself instead of the daughter, but it sounds like the daughter, though, Barbara, is clearly not in a position to be able to manage her own financial affairs to any degree whatsoever. So someone, it's almost like, could she set up a trust or something like that for her where just the money's, and maybe someone overseeing that, be it the son or someone else?
That's another good idea, Nick. Yes, she could consider a trust. Depending on the age of the daughter, it might be a special needs trust, or it may just be a sole benefit trust for the benefit of the daughter. Perhaps she is also needs someone named as her power of attorney, or if she is already cognitively impaired, a conservatorship.
And I remind folks what a conservatorship is. That is the really kind of last resort. Hopefully powers of attorney work. A conservatorship, do you have to go to court to get that declared by a judge?
You do. A conservatorship is, sometimes it's an estate plan failure. It means people did not prepare ahead of time with the documents they need by naming someone as a power of attorney. A nice way to describe the difference is a power of attorney, you share authority with between the principal and the agent. So mom would be if she named son as her power of attorney, mom does not lose any authority for herself or her assets. She's sharing that authority with the named agent in the document. Under a conservatorship, the son would have to go to court to ask the court to give him authority over mom, and they literally remove rights of one person, the mom, the ward, and give it to the conservator. So it's not sharing authority anymore. It's transferring authority from one person to another.
I'm
Sometimes
curious.
it's necessary,
Yeah.
but it's really an overused tool.
I agree.
Part of the reason why I think it's an overused tool, and I don't know if we've got another caller we need to get to.
No,
but
that's
part of
fine.
the
No, you
reason
go
I think
ahead. Go ahead. Yeah.
we have it's an overused tool is because financial institutions and title companies for real estate, they feel more comfortable with that document than they do with power of attorney because of the court oversight. And they frequently request that and give people that are trying to function, honest people that are trying to take care of a loved one with a power of attorney, they just make it very difficult for them to function. And it pushes folks into conservatorships perhaps unnecessarily.
Yeah.
It's a huge problem.
Yeah, you know,
It
it's
is a huge
interesting.
problem.
Tim has said the same thing, and I know you and he are on the exact same page on that. A conservatorship is, to me, in my mind, the last resort I'd ever want to have to seek for my parents, who probably would try to object to it. But I'm just curious, too, if you do get a conservatorship, it makes, I get the sense that makes you all of a sudden responsible for this individual. It's almost like, that's what's so weird for me, Barbara, is thinking, you know, I was a child and my folks cared for me once. If I went to get a conservatorship, then I almost have legal custody of them. And I'm wondering, too, does that make you liable for any criminal action they may take if you have a conservatorship over them?
Oh, that's interesting twist. Yeah, because you are responsible. Well, in a conservatorship, you can actually ask for being conservator over their property, so their assets, whether it's their house or their bank accounts, and or you can ask to be conservator over the person. And a lot of times folks with mental health illness need conservatorships because they're not going to cooperate with shared authority, and they need that supervision. So if you were a conservator over someone's person and that you were not paying enough attention to someone, that they committed a criminal action, there may be some sort of breach of relationship, but unless you were actually trying to encourage them to do something criminal, I doubt you'd be held responsible for the criminal activity. You may be replaced as the conservator.
Okay, makes that probably doesn't come up often, but it just occurred to me, wondering how that shakes out. Listen, we've got another phone call for you.
Not elder law.
Yeah, exactly. All right, right. There you go.
Yeah.
Let's go to Joyce. Joyce, good morning. Do you have a question or comment for Barbara?
Yes, I do.
Sure, go ahead, ma'am.
My mother's got Alzheimer's, and she's at the point where she needs pretty much 24-hour care. I mean, not care, really. Somebody there to keep an eye on her and to help her a little bit.
Sure.
We are thinking about in-home care or assisted living and a reverse mortgage to pay for it, because she has her home, but she has Social Security. Any suggestions?
Okay, fair enough, ma'am. What do you think, Barbara?
All right. If mom was truly safe to be at home and you could find adequate 24-hour caregivers, I don't know if you really plan on paying someone 24 hours a day, or if you were going to provide some of that service, you could use a reverse mortgage to help pay for that. Reverse mortgage where you pull out the equity in the house. You don't start paying back the loan until either you've moved out of the house or the owner passes away. So if mom moves into assisted living, you're not going to use a reverse mortgage to pay for the assisted living because she's no longer a resident of that house. You could sell the house and use the equity in the house to pay for assisted living. Quite honestly, unless family members are doing some of that 24-hour care, paying privately for a person to come and stay 24 hours is probably going to be a good bit more expensive than an assisted living facility. Maybe even as much as double if you go through an agency. Even though it sounds more expensive, it's really what I recommend because of the backup support from the agency, the tax coverage, the workers' comp coverage, all the things that you need to be thinking about when you hire household help.
With regard to her question, if let's just say then she considers, and I agree with you, I think you're right on point on that, Barbara. Let's say she decides to go into an assisted living facility that maybe has memory care, and she has some asset now, this house. Now, eventually, when you have no more assets, you can apply if you go to a Medicaid qualified facility, and that's a separate issue. But how would she go about, doing a reverse mortgage? Can she do that to pay for her time, or does she need to sell her house, get that money, and use that then to pay for her assisted living while she's there?
She really has to be living in the house to access reverse mortgage funds.
Okay.
Once she's moved out of the home, then you cannot do the reverse mortgage. You would need to sell the house and use the equity to pay for the assisted living, or if you could generate enough rent by renting the house between Social Security income and rent that would pay for assisted living, you could do that.
I had not thought of that. That's a good point.
Life gets harder. Yeah, life gets harder once you're trying to take care of an older adult. You're faced with a lot of tough decisions. Few people like being landlords and those kind of things, but it's how to leverage resources to provide care. Yeah.
You are so right. Well, I'll tell you, as we go to the break, Barbara and Tim helped me, and I was in a very similar situation to this woman who called. I had two parents that are now in assisted living. What we ended up doing was selling their home, and we have used the equity, as she said, and they've been using that to pay for their time in the assisted living facility. It is a Medicaid qualified facility, and so when the time comes and they're finally truly broke, no more money, that's when they'll be getting on Medicaid to pay for their continued stay at this facility. And of course, my brother and I will always be there to help them if they need it. And Tim and Barbara are on my speed dial. We'll take a break. We'll be back with more. And Barbara McGinnis, Elder Law, and more of your questions. Call us if you need help right after this.